Lovelace was not actually able to join us today, so we are left with our three excellent remaining speakers, and we're going to start. By the way, we haven't been doing introductions because, as you know, we're sticking quite closely to the time, but all of the speakers' bios are in your packages, so we definitely would encourage you to, if you don't know somebody, to familiarize yourself with that person's info. So we're going to start out with Dean Morse. We are very happy to have him back in Canada, back in the building, and he's going to be kicking off this panel.
Okay, thanks. So I'm despite being suitably scared of Lynda and Penelope and the 10-minute warning, I've still produced a PowerPoint of about 40 slides. So I think I got about 20 seconds per slide here. So I'm going to follow Nadim's line and maybe talk even faster than he did if I can. But I just, it's actually one of my favorite quotes from the Supreme Court of Canada ever. And so I just want to kind of start with this because I think it's actually a wonderful statement from Mr. Justice Binney about the way in which Canadian judiciary is slowly coming to grips with the fact that in the 21st century we're trying to resurrect what were in many ways relationships between Indigenous peoples and settlers of the 17th and 18th centuries, in which of seeing really a partnership, a treaty-based relationship, a dialogue between nations, trying to find common ground, respecting their mutual interests. Now, this, of course, is still being framed within a kind of a settler state that's not about to decolonize. But in terms of the language of this quote, if you see it in particular, what I'd emphasize is the way in which he's talking about the fundamental objective of the modern law is really to try and find a reconciliation. But the particular part of this language, which I appreciate, is and again, it reflects this kind of the evolution of judicial thinking. It's not a reconciliation of just Aboriginal peoples and their claims with the state or with Canadian society as a whole, but rather talks about its reconciliation between peoples and their respective claims, interests, and ambitions. It is claims, interests, and ambitions of non-Aboriginal peoples just as much as it is of Aboriginal peoples. And the language of the state, consistently of the federal government for decades, and provincial governments, and frankly of courts, has been Aboriginal peoples have claims, and non-Aboriginal peoples that control the society will decide if those claims are valid or not and what will be the terms of any kind of settlement. Instead, it's trying to frame something that people are, bubbling to the surface in Canada, that the nature of this relationship is dual, it's mutual. When one talks of treaties and a treaty relationship, both parties are treaty beneficiaries. Again, the language of the 20th century in Canada is First Nations have treaty rights, Crown has treaty obligations that it may honor or may not, but somehow the Crown and non-Aboriginal people have no treaty rights. But of course, in reality, much of Canada, and particularly places like Ontario, is any entitlement that non-Aboriginal peoples have got to land here is dependent upon the existence of treaties that may have extinguished Aboriginal title of First Nations, may have opened up the territory for their presence, or the very nature of the treaty relationship in which First Nations have said settlers can come into their traditional territory means that the rest of us are in fact treaty beneficiaries. And the real treaty beneficiaries in Canada are not First Nations. It's actually non-First Nations. It's non-Aboriginal people. Because you look at the treaty deals, if one side ends up with kind of 1% or less of its traditional territory, and the other side that had none gets 99% or more of the territory, who's the beneficiary out of this? It's not the ones who only end up with 1% of what they used to have. So we really need to kind of recast much of this relationship. And as I said, I think this is an effort to attempt to do so. So very quickly, I just want to try and weave together a series of kind of domestic law issues as well as looking at emerging international standards and to try and see how this kind of fits in. One of the things I want to stress about this is the tendency in Canada particularly is for people today to assume that whatever rights exist that Aboriginal peoples have somehow started in 1982. Now, for those of us who are old enough to go back before that time in our consciousness, we may know that that's not true, but for most people they don't, right? And if you look at the case law, hardly anybody looks at any decisions before 1982, so that it's easy to kind of think, well, the reason why these rights are here is it's all because of constitutional protection. And so, therefore, if you didn't have that constitutional protection, you have none of those rights. And I think so it's important to appreciate that, in fact, when we're looking at these issues, particularly in terms of Crown fiduciary relationship or duties to consult and accommodate, negotiate, these are all grounded, in fact, in the pre-constitutional status. They're all grounded in common law and equity. Fiduciary relationship is part of the law of equity that goes back hundreds of years. The duty to consult, the honor of the Crown, the whole principle of the honor of the Crown goes back to at least the early 1600s. So none of this, in fact, is new. What's new about it, if you will, is its application in the context of alleged violations of Section 35 rights. But the principles themselves, the core of that, none of that really is new. So the expectation that the Crown would act honorably, would honor its commitments, would act in good faith, these are all things that go back hundreds and hundreds of years. So we've got that, we haven't recognized the Crown as a fiduciary vis-a-vis First Nations, or now as the case laws evolved for Métis and Inuit peoples as well, really before the Guerin decision. But even that one, although it's decided ultimately by the Supreme Court of Canada in 1984, it went to trial before the constitutional change. It's dealing with pre-Section 35, so it's not derived from 35, and it's just saying that the Crown really is in a fiduciary relationship. It's an ongoing relationship. That is a way of characterizing the relationship by virtue of the fact that the Crown said unilaterally, we're the sovereign of this whole territory. Thank you very much. We're not kind of negotiating that. We unilaterally declare our sovereignty. And therefore, any indigenous sovereignty is somehow going to be subservient to it. And secondly, of course, the very nature of Crown claiming ownership of the land. Radical title. Crown has underlying title. And that's these two starting points for the relationship, from the Crown's perspective, of course, means that the Crown has taken on fiduciary responsibilities in relation to Aboriginal people. So that's the nature of the relationship. Now, the way the law has evolved is having that relationship means that a fiduciary will owe or can owe certain duties in relation to the beneficiary in particular contexts. Not everything. A parent is a fiduciary in relation to his or her child, but that does not mean that everything the parent does in relation to the child is a function of a duty. You must pay an allowance, for example, or something like this. And that if you don't do what you honor your promise about, yes, you can stay up till 9 o'clock, no, go to bed, you're driving me crazy, scenario, that somehow that means that's a breach, right? So, but the relationship is an ongoing one. That's how you can characterize in law the relationship between parent and child, doctor and patient, trustee and beneficiary, Crown and Aboriginal people. So we have that relationship. And so the Crown just can't ignore it, but it doesn't mean that it's bound by all aspects of it. So we've drawn on the private law of fiduciaries and applied it in this unique context. The added dimension, of course, that makes it tricky is the Crown at the same time is the government, owes an obligation to all Canadians. So it has to address that. So we've got, therefore, an expectation that the Crown will act honorably. Section 35 gives some constitutional weight to this, and it absorbs some of these common law and equitable principles, but it doesn't really create it. It does, however, eliminate Crown power to extinguish those rights post-1982 unilaterally. So just a quick look at a map. So Canada, half of it by treaty, half of it not by treaty in terms of historical treaties. So in and of itself, that means you look at that, it means, well, half the country then Aboriginal title was unresolved until modern day. Right? And even, of course, where it was resolved, such as Ontario, looks to be all completely covered by treaty. Well, in fact, Ottawa Valley, not resolved. Unextinguished Aboriginal title accepted by Ontario and Canada. But even in areas where you have treaties, and those treaties explicitly state yield, cede, surrender. That's the treaty in English. That's who you will talk to about in Aotearoa in New Zealand. There's a Maori version of the treaty as well as an English version of the treaty, and they're not the same. We don't have that benefit in Canada. So we've got an English version of treaties drafted by lawyers using legal language that's not reflected in the oral negotiations of the treaty and the translations of those negotiations, leading to a fundamental disconnect, so that many treaty First Nations in Canada will say, despite what the language in the written English version of the treaty, that does not mean we ever surrendered our interests in lands. And so that leads to disconnect, because mining companies are told by the Crown, oh, look, that's Crown land, free and clear. Aboriginal title's gone. It was extinguished by treaty. And then treaty First Nations say, no, it's not. We never extinguished it. Doesn't matter what that says. That's not what we negotiate. Fundamental kind of disconnect that really plagues much of what's going on in Ontario, but all through the prairies and some other parts. So we've got a duty to consult now. That's clearly a cornerstone in the relationship. It comes out of the common law. That it really is grounded in this kind of honor of the Crown, not fiduciary relationship, but somewhat connected to it, because it also requires that kind of honorable behavior. Supreme Court of Canada is real clear about that this has deep roots in Canadian soil, that we must understand the nature of that honor of the Crown, its application very generously. We know that it's triggered whenever the Crown knows about alleged rights. So in Ontario, treaty rights are province-wide at the very least. The Crown always knows, it's deemed to know, when it's thinking of doing anything that might adversely affect the interests. Hard to imagine that mining would not qualify. So there's always that kind of duty in Ontario. So we have stages to the consultation. We know that we have to consult about a wide variety of issues that flow in this. We know that there's a low threshold here, so the Crown can pretty well accept that it's going to have to consult all the time with somebody. The issue is just to figure out who do they have to consult with and how extensively, but they know they're going to have to do something. It arises on Crown land, on all kinds of interests. We've got some case law saying that arises on privately owned land as well, so long as the Crown has some permitting or licensing function, such as to authorize a mine. So it seems like it applies kind of everywhere. The case law is very clear that the obligation's on the Crown. We look at the Ontario Mining Amendment Act changes, it's putting all of that on the mining companies. You know, it's because the review question is, have the mining companies consulted? So we have that, again, a kind of a bit of a disconnect. Court saying it's the Crown's obligation, Crown offloading it to the private sector. Supreme Court of Canada said private sector has no duty to consult. Here we have kind of a statutory duty. So how does that change things? We're not quite sure. Maybe it means that the courts have to revisit this question. Maybe there is, in fact, an express duty on private sector. There's clearly a self-interest in the private sector to do this, but it may in fact be a duty, and therefore it may be legally enforceable, and therefore violations of the duty may give rise to all kinds of remedies that I don't have time to talk about. Importance of difference between duty and desires. I tell you, I'm afraid of Lynda, so I got to keep my eye. It's not just a duty to consult, it's a duty to negotiate. And what we're getting from the courts, I think, is really a duty to negotiate the application of Section 35, constitutionally protected Aboriginal and treaty rights in relation to issues, so that it's actually come up with the result. Find, and whether we frame it as accommodation or agreement, that's the objective. Now, courts have said there's not an obligation to agree, at least not unless there is an Aboriginal veto or Aboriginal consent is required. While we don't have case law that directly gives us an example where they've required it, we do have in Delgenbook saying subsurface rights are part of Aboriginal title, so therefore it suggests if somebody's going to come along and extract it all, you probably need consent of the owner. So we've got remedies for breaches of this. That's significant. That's why mining companies are paying attention. That's why governments are looking at changing legislation, because mining companies want to not have these kinds of problems. It costs you a lot of money if you get caught with shovels in the ground and you can't proceed. We do have some examples in other jurisdictions, so it's not, these issues are not unique to Canada. We've got international human rights provisions. We've got some old ones, even the International Covenant on Civil and Political Rights, Article 27 talks about a right to protection of cultural continuity. We've got case law from the UN Human Rights Committee saying that includes traditional ways of life, it includes economic behaviors, traditional economies. So if you're going to disrupt land use, it's going to disrupt things such as wildlife harvesting, etc. That can give rise to a violation. We obviously have the UN Declaration. There are a whole bunch of provisions in there. The OAS drafts. Let me just flag in particular in the UN Declaration, obviously about right of self-determination, but we also have a variety of provisions that talk about traditions and spirituality, connection to land. We've got a right to maintain a distinctive spiritual relationship with traditionally owned lands, rights to the lands, rights to use and develop the lands, requirements for independent redress mechanism, which Canada is objecting to. It's one of the reasons why I won't favor DRIP. Apparently, Canadian courts won't meet the test of an independent redress mechanism. The right to conservation, protection of the environment. So we've got a whole bunch, traditional knowledge, state obligations, free, prior, and informed consent obligations, none of which is really being reflected in Canadian legislation. So we've got nice international standards, not yet enforceable or adopted into domestic law in Canada. Got some duties to consult and obligate and accommodate, but they're not the same thing as free, prior, and informed consent, so we haven't yet met that kind of standard.
Thank you.
Pretty well 10 minutes over.
Very, very efficient.
Oh, yeah. Let me give you the microphone.
It's a very gendered.
It is a gendered microphone.
How about on your sleeve?
Yeah, can you help me?
Do you want? No, I don't think you
On my
want it up
sleeve?
on your neck. Yeah.
Okay.
Just talking to your arm. You know.
So I'm as antiquated as the Quebec Mining Act, and I don't have a PowerPoint, so I'll try to be entertaining by myself. So first of all, I'll present just the context in which I've started to think about this issue, and it's the context of the Innu people in Nitassinan. So just very briefly, the Innu people, to not confuse with the Inuit who live in the Arctic, live in 11 communities that in territory that they call themselves Nitassinan, that Quebec calls the Côte Nord, or the northern coast. And 2 of their communities are in Labrador. So most of Innu community do live in the Quebec North Coast. So this region is particularly renowned for its natural resources. Quebec call it natural resources region, especially for its hydroelectricity, for its forests, and for its industrial minerals, notably iron and ilmenite ore. So the Liberal government of Jean Charest have announced quite recently, or is aggressively promoting the intensification of extractive activities in the north, which include all the territory on the north of the 49th parallel, which include the James Bay and northern Quebec territory, but also the Côte Nord or Nitassinan, as a place where the Charest government, in very colonial language, wants to expand our last northern frontier, and it's exactly the words, the terms he used, and open this space, our space, for what he calls sustainable development. So these resource extraction projects takes place in a highly conflicted landscape. So the Innu people, unlike the Inuit and the Cree and the Naskapi, have not signed land claims agreement, and they've actually been negotiating with Canada and Quebec since now over 25 years. So this process of negotiation has been very, very difficult and frustrating, and nonetheless, because while negotiating, Quebec continues to do business as usual and continue leasing lands for mining industry, forestry, etc. So the Innu have been suing quite a few times, or at least threat to sue quite a few times lately for the complete lack of consultation over these issues, and etc. And as Will also mentioned, on the mining side, relationship with Indigenous people have been a little less conflictual than in Ontario, but it might change. There's a huge increase in uranium exploration right now in Nitassinan, in a place located 20 minutes away from Washat Maniotinam community, and this community have not even been consulted over this mineral exploration. So the exploration just resumed 2 weeks ago, so we'll see if they decide to take the Algonquin side and occupy the land and actually protest to impede this exploration to go on, or they'll decide to sue. This is all to be seen. So this is, I think that the Innu ongoing struggles against the extraction of natural resources on Nitassinan provide a useful lens to reveal and examine the shortcomings of the Mining Act and the oil mining regime in Quebec as regard to the consultation and accommodation of Indigenous people. So my short remarks will focus on 3 points. First of all, the shortcomings of the inadequacy of the current Mining Act for consultation, and especially at the stage of mining exploration. The second will be about the lack or absence of a detailed and publicly accessible policy or regulatory framework for consultation in the mining context. And the third I will address or discuss briefly, if I have time, the very problematic approach of the Quebec government for the implementation of the duty to consult in that province. So for my first point on consultation and mining exploration, I would say that the Mining Act has never been amended to reflect the evolution of the constitutional law regarding Indigenous people. So nowhere in the Mining Act you'll find a recognition of Aboriginal and treaty rights of Indigenous people, and the fact that mining has to be done in accordance with these constitutional rights. And nowhere you find in the Mining Act recognition that Quebec has the duty to consult and to accommodate Indigenous people in mining. Quebec has also published in last June a mining strategy that announces some of its policy for further modification to its legal regime. And even this proposed policy is very unsatisfying, both on the environmental protection side and also in the consultation and accommodation of Indigenous people. So in Quebec's mining strategy, Indigenous people are generally depicted as all being very willing to enter into the mining industry and participate in it. And what is proposed is rather negotiating impacts and benefit agreements between the extractive industry and Indigenous people, and seems to focus much more on environmental impact assessment as a way to consult Indigenous people rather than on nation-to-nation relationship that will be based on constitutional duties. I'll come back to that. And on the field, we can see, as for the uranium mining very close to Washat Maniotinam, that Quebec tends to assume, as it does throughout the Act, that mining exploration does not impact at all the land, or at least is not impacting Indigenous people rights. And I think that this radical different treatment of exploration versus extraction is highly artificial and, not surprisingly, quite convenient for high-risk economic sector that is dominated by small junior companies, right? But it is hardly justifiable considering the real impacts that this industry has on the land. And Brad could circulate. I don't. The Washat Maniotinam published went on the land, on the uranium mining land, and took some pictures last summer that really shows how the uranium exploration is done on the land. And you see through these shocking pictures, they're worth 1,000 words, but it has actually tremendous impact on their land. So I would suggest for Quebec to, when it will revise its Mining Act and propose it in a few weeks from now, to include provisions for consultation, not only at the extraction stage of mining development, but at the very stage of staking claims, or at the very least before exploration activities are consulted. So this takes me to my second point, which is the lack or the total absence, I don't know if absence is the word in English actually, but absence, okay, of a consultation policy that is public and completed. So it would not be sufficient, as I think it's not in Ontario, and I don't know how the context of policy development and consultation in Ontario, but to simply recognize in the Act that Quebec has a constitutional duty to consult and insert it just as a recognition. It needs to be accompanied by a fully developed consultation policy and fully detailed. And to be sure such policy exists in Quebec, it's been adopted, and you can find it on the Quebec government website. However, reading it after you read Taku River and Haida Nation provide you no more information in the sense that they simply summarize existing case law. And, but they do say that different sectors of activity can adopt their own policy of consultation. So very interestingly, I was curious about it, and I called Natural Resources Department to get the guidelines applicable for the mining sector. And I was told, well, we're going to call you back, and I had to go back and forth on the phone, and then I had to put down a formal request for access to information, and so far I've not seen any documents coming back in my mailbox. So this is not what I call a transparent way of conducting honorable relationship with Indigenous people. So I would suggest that a full-fledged regulatory framework detailing what Quebec will actually do to fulfill its duty to consult and accommodate Indigenous people would actually foster transparency for once, but also certainty, the certainty that is so dear for governments in making sure that these duties are implemented and that there won't be lawsuits risking to stop some economic development projects. So it might be in the interest of all actually to have 2 minutes. That's good. So I can make my third point as a conclusion for this last 2 minutes, which is the very problematic, I find, way that Quebec is taking for implementing its duty to consult and accommodate. So as I said before, Indigenous people are depicted as people who want to participate in, as partners, in the mining industry. So the way to deal with that is to, at least in the mining strategy just published by Quebec, is to foster impact and benefits agreement, which are mainly negotiated on economic terms, and also ensure consultation of Indigenous people through environmental assessment process. I won't go too much into the impact and benefits agreement. We could discuss it in discussions. I would just say that you cannot count, Quebec should not count too much on the environmental assessment process in order to consult nation to nation with Indigenous peoples, as the process as it is now in Quebec do not respect the conditions set it down in the Taku River case for this process to be able to count as a full consultation, meaning that Indigenous people, for instance, would participate to public debates with other stakeholders, but would have no say, notably in the decision-making process. And there's other shortcomings of the general regime that makes it not suitable for a nation-to-nation consultation and accommodation. And my last word would just to share with you a malaise that I have had for a little while, and it's with the duty to consult and accommodate. And I've been to a few duty to consult and accommodate conference lately, and we had this wonderful, fantastic discussion on the legal parameters of the duty to consult and accommodate. When there's a veto, when there's none, when you just have to send information, full consultation, etc., etc. And all these discussions took place in a very technical, legalistic discussions, right? That could have been very fascinating for all the lawyers around the table. But leaving these conferences every time, I'm wondering, we missed the point. We didn't talk about relationship. We didn't talk about how to foster better relationship on the ground, and we forget all about it through focusing a bit too much on the technicalities of consultation. So I'll stop here. Thank you. 10 minutes.
Oh, right. do have a lapel, so lucky me. I'm going to speak in English, mais j'ai fait une version de cette présentation pour la première fois en français durant l'été, donc si vous avez des questions en français ou si vous voulez la version française, n'hésitez pas à me demander. Being an absent-minded professor, I actually forgot my notes, and Professor Collins shooed me out of my office this morning to get me to come down here, so I think I remember what I was going to say. What I was asked to do was to talk a little bit about the aspects or other kinds of law or other kinds of legal issues that intersect with mining claims on Aboriginal land. So I think to really understand how some of these negotiations between Aboriginal peoples and the government unfold, one also has to be familiar with the following areas of law. Environmental law, obviously, but also a lot of the rules and regulations around civil liberties. How do environmental groups and Aboriginal groups make their voices heard publicly? And what are the restrictions on their abilities to do that? And we'll see some of the restrictions come from the law of injunctions, right? The ability of a private mining company to get an injunction against Aboriginal groups to prevent them from voicing their views. The same injunctive power is available against non-Aboriginal environmental groups as well. Then there's the law of contempt, which is the way that, that courts enforce these injunctions, right? The ability to throw people in jail or to fine them and so on if they are not complying with the court-ordered injunction. Then there are also more technical issues about how these prosecutions unfold, particularly rules about evidence, right? As you'll see in a second, the Crown has a fairly well-developed duty to disclose the evidence on which the breach of the injunctions is based. But private mining companies, when they are suing protesters, both Aboriginal and non-Aboriginal, do not appear to recognize the same duties to disclose the evidence that they're going to rely on during these prosecutions. So this is obviously very problematic, right? The other aspect of this is when conducting these sorts of this sort of litigation where a non-Aboriginal or an Aboriginal group is trying to vindicate its environmental and Aboriginal rights, one of the main deterrents is the possibility of adverse cost awards awarded against them if they lose, right? So there's a lot of developments happening in the area of costs these days in Canada, and I'm sure Will could talk a little bit about this. He's been quite involved in it. But it's another aspect of the puzzle to be aware of. The types of cost awards that we might want to discuss are advanced cost awards, right, where the court says before you come to the court, we will ensure that you will be able to pay for your litigation, Aboriginal groups or non-Aboriginal environmental groups going forward, right? But then there are other issues, not about advanced cost awards, but about just regular cost awards. So in other words, if the Aboriginal group or the non-Aboriginal group loses their claim, what kinds of law can they rely on to try and insulate themselves against being beggared, basically, by litigation which we will presume was meritorious, both on an environmental point of view or an Aboriginal point of view. In other words, we're assuming that we're dealing with litigation with a good, valid point of law that was debatable and that really had to be resolved by the court. Isn't it of public benefit for those issues to be resolved by courts, right, without necessarily penalizing the environmental or Aboriginal group, right? Because it's thanks to them that the court was able to decide what was supposedly in the public interest on this point, even though it didn't go in their favor, right? So these are some of the other aspects of the law that I think it's important to understand how they intersect with Aboriginal issues relating to mining, exploration. Now my personal experience in this area is sort of limited, so I was going to just talk about that limited experience because I was involved with consulting with EcoJustice on some litigation involving non-Aboriginal environmental activists who were trying to get the public to be aware of acts of Frontenac Ventures Corporation, a private mining company, that were exploring on Crown land in the Kingston area near the Sharbet Lake region, where some Algonquin groups have the land claims going on. And that had been recognized by the province, and they've been in negotiations since 1994, but they weren't aware that these mining, that this mining exploration was going on. So let me just talk about give a few examples to illustrate some of these theoretical problems that I discussed earlier. First of all, injunctions. What happened in this case is that the Aboriginal group, the Ardoch and the Shabbat, found out that there was this mining exploration going on their land, and so they wanted to sue the mining company to get them to stop. But the mining company, of course, wanted to retaliate, and so they decided, well, we'll get the court to issue an injunction to prevent these Aboriginal groups and environmental protesters from preventing us to have access to our land. Now, when it came for the day where this injunction hearing was to take place, the Aboriginal group said, we would prefer to negotiate with the government rather than have an adversarial process. And so we're not going to participate in this, and they provided no evidence, and the court issued the injunction anyway. In the absence, at what we call ex parte, so in other words, in the absence of any evidence on the part of the Aboriginal peoples. Now, the fact that this can occur, I think, is a serious problem, seriously impedes the government's credibility and its ability to consult and negotiate on an ongoing basis. Right? Also, the fact that the government was there in court, but their voice was certainly not heard when the private company to whom they are devolving consultation responsibilities said they want to proceed with this injunction hearing, basically ex parte, right? So that's one illustration of the difficulty of that our law on injunctions poses for the resolution of Aboriginal issues and environmental issues. Another issue that, so then what happened is that the protests of Aboriginal, non-Aboriginal people continued in spite of the injunction. And of course then the private company decided, well, we're going to sue them for contempt of court to get them thrown in jail, which of course, as you've probably read the newspapers last year, happened in the case of Bob Lovelace and, I'm sorry, I've forgotten her name now, the other leader of the Ardoch. No. No, it was in my notes. So here, this raises, again, interesting questions about the duty of the Crown and its duty to consult, because often it seems to me it would be better if in these prosecutions for contempt of court, if the Crown took over the prosecutions, because I think the Crown recognizes its duty to disclose evidence in law, which we had a real fight with the mining company, and they told us they had no duty to disclose the evidence on which they were going to rely for throwing people in jail. I think the Crown wouldn't have had that kind of difficulty, right? At least acknowledging its obligations. Whether they could have gotten hold of the evidence is a whole different question, right? Then another thing is that, I've forgotten what the other thing was. I think I've combined, I've combined my 2 points into one. Oh yeah, the other thing is the different motivations that the government would have in conducting these prosecutions versus the private corporation, because one understands how private corporations make their decisions. Is it cost effective or not for me to proceed with this litigation or not? Presumably that would not be the Crown's understanding of its role, given its fiduciary obligations and its duty to consult obligations that Brad has pointed out. Perhaps not. But one would hope that different norms would be in play had they taken the leadership role in this case. I have one other point that I wanted to make, that arose out of this litigation, which is the law of contempt of court in Canada. In the United States, there is a very clear difference between criminal contempt, which is very serious and can result in jail time, and civil contempt. Now, in Canada, this difference is not clear. So the result is that the private company proceeded by civil proceedings for civil contempt, but in Canada, you can obtain jail sentences for proceeding in civil contempt. And this leads to lots of problems because, again, the company was trying to say, well, it's civil contempt, so we don't have to give you all the protections you would get if you were doing a criminal law prosecution. And yet, nevertheless, the result was that people were put in jail. You see? So this is an area, again, where we really need to, either through the common law or through making the government understand that legislative change is needed to prevent what are called slap suits, right? Or mechanisms that private companies can use to prevent objections, to what they are doing in a democratic forum. So what are my concrete suggestions, because I have -1 minute? Well, I think the government ought to be articulating how it understands that its duty to consult and negotiate in good faith is going to affect its confrontational role in Aboriginal land claims and its role in these kinds of slap suits. Because I think there should be a clear normative link, and there's not. We might want to discuss whether it would be good practice for the government to take over these sorts of private prosecutions for contempt. And you'll note another decision I want to make you aware of is the Ontario Court of Appeal decision in Frontenac and Ardoch, because there the court clearly said that injunctions are completely inappropriate in this kind of situation. And unfortunately, they couldn't revoke the injunction because it wasn't being challenged, but they basically slapped Justice Cunningham, Associate Chief Justice of the Superior Court of Ontario, on the wrist for even thinking that an injunction could be issued on an ex parte basis when the government is in consultations with Aboriginal peoples. We need to resolve clarify the issue of public interest cost awards, either through courts or through, which is what Equal Justice is doing now, or through other means. And the last thing is that we need to understand better the role of Aboriginal law in informing duties. Not Canadian law relating to Aboriginal peoples, but Aboriginal understandings of their law. Because in that case, interestingly, at the very first few paragraphs, the court said that the Aboriginal people involved in this were proceeding in accordance with William Commanda, an elder of the Algonquin. He had said we should have no more uranium mining on lands claimed by Aboriginal people. So this was an understanding, an enunciation of the Algonquin people's legal understanding of how their protests were justified. And the Ontario Court of Appeal cited this as one of the things to consider. So I wonder if there's any way of advancing and pressing that more to see whether Aboriginal law what the Aboriginal role of Aboriginal law is in these sorts of proceedings. So I hope that gives you, despite the absence of notes, a little bit of an overview of some of the intersecting issues that arise. Great.
Okay, we have 16 minutes for questions to the panel as a whole before we go ahead and do our breakout sessions.
Good thing Bob wasn't here. Though just time-wise, I mean, we would love to have had it.
I have a comment just on what I just wanted to sort of say what my understanding is of the amendments to the Mining Act, the Ontario Mining Act, to address some of these issues about consultation. Consultation has now been included in the Ontario Mining Act, as Maureen had pointed out, but the obligation, as far as I understand it, doesn't arise until the exploration stage. And that's been justified because now staking, which is the process of mapping out a claim, is now supposed to be done virtually. Is that correct?
They're phasing in that.
Phasing in this kind of virtual mapping. So there's supposedly then, if it's all done virtually, then there's no environmental impact. But it's not clear in the Act that there's going to be consultation before that virtual staking happens. And so you still have this thing happening where you have staking on Aboriginal lands without any consultation, because the consultation then doesn't start until the exploration stage.
So even more staking more quickly, because you can just go online and say, I'll take that and that.
Yeah. So I think that that's a huge problem that has been incorporated into this new Act. And also, the point that Brad, Sophie, and probably I think even Graham made was that this duty to consult has been delegated to industry in one of these cases, and it's not clear in the Act because the consultation is going to be the protocol or the criteria for it won't come out until the regulations. So we don't know whether consultation is going to be delegated to industry or whether it's going to be assumed by the province. And also, we don't know whether it's going to be any broader than what's protected now under the common law, or under Section 35. So whether consultation will be anything more than what we get. And I guess the other point was about, it's still discriminatory because there's a protection now of certain private property owners under this Mining Act who can't have their lands staked or can ask to have their lands not staked, but there's still a problem with, in the near north, Aboriginal communities being subject to staking. So I just wanted to make those points to have.
J'ai une question pour tous les trois. Sur le sujet de l'uranium et l'exploration de l'uranium en proximité des communautés, est-ce qu'il y a, à votre avis, des obligations constitutionnelles, puisqu'il y a des effets potentiels sur la santé? Alors, je pense à la sécurité de la personne et le droit à la santé sur la Charte québécoise. Are there constitutional implications here outside of Section 35?
Oh yeah, under the Quebec Charter, right? The right to health is not directly protected, but we can think of the right for security of the person under the Quebec Charter of Rights. We could think of there's a right to property, but it's limited, and it's far from certain that Indigenous property would be recognized as protected by this provision. So I believe it could be, but I'm not a specialist enough of Section 6 of the Charter of Rights and Freedom to tell you if there would be actually, and what would be the hurdle of a lawsuit based on the right to security under the Quebec Act. But the problem would be causality. It would always come back to causality, right? And to establish, like, the doctors are really, really mobilized on the Côte-Nord right now, and are all threatening to leave the region if they move on to exploitation, like basing themselves on lots of studies showing. But I believe that these lawsuits would face a tremendous challenge on proving the actual impact on health. So that would be, I think it's possible, but it's just hardly one.
Can we use the precautionary principle on that? We know, for example, in the tar sands,
Yeah.
the local position in the area of the tar sands has gone international and saying basically, has gone to investor meetings and said, if you invest in this, these people's blood is on your hands. Like, he's already seeing health impacts, and he's comfortable making a scientific conclusion that they're resulting from. I'm just wondering, I hope that we can use sections other than Section 35 when these very basic fundamental issues of, survival are at stake.
A point I've been starting to think about, if I could just add, is 46.1 of the Quebec Charter and how it could inform a broader interpretation of other sections of the Quebec Charter, including the right to security, in order to protect environmental interests. Because by embedding the right to a clean environment in the Quebec Charter, it's also an expression of the importance of this right for Quebec people as a fundamental value, right? So all other provisions of the Charter could be interpreted under this value to, for instance,
be maybe less strict on the causality, like in integrating into charter analysis the principles that are otherwise recognized in the Sustainable Development Act, including the precautionary principle. So.
Just to add to it, but obviously there's the equivalent in terms on the Canadian Charter side, Section 7, but again, causality issues. The other way of doing, coming at it too is on the international law side. And so we've got a growing recognition of a right to health, very clearly in terms of children under the Convention on Rights of the Child, which also expressly includes Indigenous children. So to the degree to which one wishes to look at these principles in that context, where there comes to geographic factors at play, one can argue that that leads to contravention of the Convention on Elimination of Racial Discrimination, so that there are a variety of opportunities on that side. Now, to date, that hasn't really led to mining companies not proceeding on these issues anywhere in the world, but it is at least a way to try and impose greater rigor on state behavior in terms of the domestic policies.
My last follow-up, but I'm just wondering, I know you haven't, I mean, it seems to me that the Shauli decision suggests that a threat to health is enough to violate Section 7. And so, isn't it true that we don't have to prove, certainty of harm? We just have to prove a credible threat. Am I right or am I wrong?
Well, I think I'm thinking too much as a law teacher in this regard. And so clearly what we've been talking about is, I think it's fair, even if we got over the hurdle of showing that there was some injury to security of the person, right? The problem is identifying the principle of fundamental justice that this is not in accordance with. And it's Section 7 and Section 1 of the Charter, right, have these balancing tests that basically allow the government to say, yeah, we're infringing your rights, but we're justified. And there's a conservativization that's going on in jurisprudence at the moment. For instance, Sujit Chowdhury wrote an article about Section 1 where he basically says courts are completely incompetent to assess cost-benefit analyses of various sorts, and so they have to defer to the government so long as they can provide some credible evidence on the basis of which they made their decision. This article is getting quoted by courts throughout Canada all the time now. And he's very unapologetic about Sujit. When I asked him, I said, I went to high school with you, what are you doing? But anyway, didn't work. So we have a lot of work to do here on these Section 1 and Section 7 cases. It's even worse than Section 7 because Brad mentioned the rights of the child, but in the spanking case that there was they felt that there was no consensus in Canada that we have to legislate in the best interests of the child. So that is a real difficulty too, not an insurmountable one, but we need to put our intellectual effort on countering these conservativizing forces and the balancing tests in our legislation, in the Charter jurisprudence, and then also using international sources more creatively to try and identify a concrete principle of fundamental justice that we can hang our hat on.
Could it be lack of consultation, for instance?
Yeah, maybe.
Brad, could I ask you mentioned the UN Declaration on the Rights of Indigenous People, not ratified by Canada, also not ratified by the United States.
Or Australia or New Zealand. Those are the CNUSIS, the four countries.
Okay, the question I had is it nonetheless, are the principles arising under that convention nonetheless rising to the level of customary international law?
Well, I'd make two kind of points on this. First off, the fact that Canada didn't vote in favor of it doesn't matter. Declaration's a declaration. It was overwhelmingly passed. It's there. It's not, because it's not a covenant or a treaty, you don't get to say, well, it doesn't apply to us if we don't sign on. So it does apply to Canada. So Canada is bound by it. The declaration speaks very clearly in terms of obligations on states to implement the terms of the declaration. Now, on the other hand, of course, it's still a declaration. It's unenforceable. So it's somewhat hortatory. But I guess the point I'd say is that Canada cannot say what the current government keeps saying, which is, since we voted against it, doesn't apply. We get a kind of get out of drip free card, because I just don't think that's true. And similarly for the U.S., Australia, New Zealand, Australia's promised to move offside, although it's, you get into the politics of it, the Commonwealth government is willing to do so, Prime Minister is willing to do so, states don't want to because they're nervous. New Zealand is talking about moving in this regard. There's some hints out of Barack Obama as well that U.S. might move in this regard. So Canada could end up being the lone holdout. But in any event, it's there. In terms of has it risen to international customary law status yet, I think there are provisions within the Declaration that have, but I wouldn't say that the entire Declaration has. Yeah, I think there are a number of provisions in it that do track other things, such as Convention on Biological Diversity. And so I think we can say, well, then those fit. But some of the provisions are really, the only thing one can point to is International Labor Organization Convention 169 as being similarly worded on some. And so hard to say that it's reached that level of state practice. But things are happening. Various countries have now kind of moved to try and give some domestic effect to the Declaration. Bolivia was the first, but others are following. And so then it starts to come in perhaps through the state practice route, and therefore it could obtain that kind of level of authority, which then makes it even more conceivable that Canadian courts domestically could be using it as at least an interpretive guide in dealing with Section 35. And the great thing about something like the Ontario Mining Act is you got all these new provisions. There is no judicial guidance. You've got to look to something to try and figure out what they mean. Why not look to international standards?
Actually, I have one other follow-up, not related to the first question. I want to squeeze it in.
Yeah.
I'm sorry, who's chair? Who are you?
Flat hierarchy, no one's in charge.
Both panels have talked about slap suits, and I thought it might be helpful to sort of get a rundown nationally in the province, whether there's been any movement on anti-slap legislation. I know Will knows about the Quebec situation. And somebody just because there's nothing going on in Ontario that's worth talking about, but there might be something useful going on elsewhere.
Not to my knowledge, but it's not really my specialty. Do you know if you guys were writing about this too, right?
Not slabs. No, we were writing about participatory.
Okay. I would just comment that we've recently gotten a number of calls from the Premier's office saying they're looking at this hard. So, Ontario.
Oh, the region.
Yeah. So who knows what? It seems like something's bubbling in Ontario.
Yeah, that's my understanding as well. The environmental commissioner this year highlighted the need for anti-slap in his annual report, and I was recently at a group of a number of environmental groups in Ontario meet and discuss priorities, and then that initiative is just going up right now. There's a website, and that's one of the identified priorities. And there were some political people at this meeting, and we got the sense that the entire government might be willing to move on this. That's nothing to stick your hat on. It's a possibility in Ontario.
But you can see all the complex elements say that have to be in effective slap suit, anti-slap suit.
I doubt it's going to be as nuanced as what you were talking about.
And one of the things you have to do is ensure that it also applies to administrative tribunals.
Right.
Most of the focus has been on courts.
Yeah.
That's certainly what the commissioner was focusing on. He was focusing on OMB hearings, and he wasn't actually focusing on defamation suits, which are really the primary vehicle for slaps.
And it really was focused on land use planning issues.
Because we had that $2 million costs request at the OMB on the big point.
Yeah.
Yeah, maybe it's just more of a comment, but just to keep that one thought going that I thought was really important. A number of years ago, I had a delegation of Kanaks from New Caledonia come to Canada because they were facing a huge project by Inco, and they wanted to figure out how Canadian Aboriginal people were dealing with Canadian mining companies. And one of the most fascinating meetings that we had together was with Matthew Kunkam, who was still the Grand Chief at the time. And they started off their discussion, and you know, they've all had French training and they were all in suits and ties, and started off the discussion with a nice setting out of explanation to Matthew Kuhncom about the fact that really it was going to be very difficult for them to fight this project, this INCO project, because unlike Canadian Aboriginal people that had some rights, and these all relate back to the things you were talking about, the Constitution, but pre-Constitution, unfortunately French law doesn't actually recognize Aboriginal people as a distinct group that need any kind of relationship or rights or fiduciary, you know, relationship or any of that. And Matthew actually stood up and said, that's all hogwash. He said, all that talk, you know, that legal talk about where our rights come from is nonsense. Never mind the Constitution, even going back before the he'd say go back before that. That's where our rights come from. They come from the fact that we're here and this is our land and we were here first. And he said, that's what you do. You said you don't sort of try to figure out where your rights may come from. You just stand up and declare your rights. And it was really quite striking the impact that that had. So where they thought that they couldn't sort of figure out in law how they could make claims, he was saying, forget the law, just stand up and make the claim. But of course, he then started talking about how that claim had been backed up by blockades and, you know, demonstrations and that sort of thing. So it sort of goes back a little bit to the point that one of you made, I think maybe the last speaker, about Aboriginal law, you know, and actually bringing that more to the fore and saying, well, hang on a moment, there's probably two kinds of thinking and two kinds of law going on here, even if it's one is not as elaborated. And starting to sort of bring that up more and giving that more credence. And I know that's a long road to hoe, but you know, I think it's an important point to make.
Well, these two teach Aboriginal. Is there any purchase for that kind of thing, or was that a sort of a throwaway line volunteer for a deal? No reports at all.
It's like so many things. You know, there's again another example of disconnect. Indigenous societies, by virtue of focusing on the importance of conveyance of history and knowledge orally, means to keep knowledge alive. And most Western societies rely on writing things down, and therefore nobody has to remember anything. And so and I use that as a lead-in for the fact that if you looked at Canadian law in the 1800s, you'd see widespread acceptance of Indigenous law as law. And the question really being the degree to which Canadian courts and common law can recognize Indigenous law or not. But there's no question about it being there, and lots of issues being resolved under Indigenous law, and the Canadian courts in Quebec and in common law Canada saying, okay, yes, we will decide this case in accordance with the Cree law, for example, and so that was it, the Ojibwe law, etc. Right? So we've forgotten all about that, and it kind of got revived in the Northwest Territories in the 1950s by Justice Sissons, and so now you still find in the NWT active use of Indigenous law resolving issues such as custom adoptions, etc., and some codification of this by statute. But in Southern Canada, we've kind of forgotten all this stuff, right? And every now and then it'll come back to the fore when someone actually argues it, raises the issue, or a judge raises it on his or her own. But you know, we've got all of those solid roots. So clearly one can look at it. And we've seen it, it comes up, for example, in Delgamug itself, Supreme Court of Canada is talking about the content of Aboriginal title is determined by Aboriginal law. Not Canadian law about Aboriginal people, but it's determined under Aboriginal law. So what is the land use of Aboriginal title? Well, that's a function of Gitxsan law, or Wet'suwet'en law, or Nisga'a law, not common law. So lots of recognition of it in a sense, but it hasn't really kind of captured the thinking of most people, so as to really be operative. And as far as governments are concerned, they're completely oblivious to it, non-Aboriginal governments.
Sophie, did you want to add anything before we break out?
Yeah, like outside the difficulties of the reception of Indigenous law in Canadian law, which is quite hard to us, because even if the Supreme Court does recognize that Indigenous people law should be a source of law in Canada, when it comes to actually deciding or like defining the criteria for Aboriginal title, they rely almost exclusively on common law, saying possession and occupation is what you need to prove, and Indigenous people law becomes a material source of proof, right? You can use your law system to prove you were occupying the land. So if your law speaks about the land, it shows occupation, but common law still dominates. So there's a long road, but I think you're right. By coming back to the old case, we can. I think we can, it might come back. But there's another way where Aboriginal law is not a material source of law, but actually a formal source of law, and it's through modern treaty and claims agreement. And I'm thinking about more recent self-governance agreement, including the Labrador Inuit agreement. There's the uOttawa government has been formed and have legislative power over many broad subjects and have adopted their own constitution. And under the constitution, it's very interesting to notice that Inuit customary law has precedence over Inuit legislated law by their governments. So they're really putting customary law as a formal source of law in uOttawa for governing diverse topics. So it does exist, but incremental.
All right, well, we're going to move to the breakout portion of the program today. We're going to split into two groups. I'm terrible at spatial things, but does it make sense just to go from this side of the room?
Yeah, or people could choose which group they want to go to.
Okay. The questions are
So
what am I?
one group will look at priorities for further reform of mining legislation, with keeping in mind how Indigenous rights will be effectively integrated into Canadian mining law policy. And the second group will look at roles for municipal, provincial, and federal and First Nations governments. Again, thinking about that question about Indigenous rights being integrated.
One group stays in the room with the food, and the other group goes to the couches. So there's an equitable distribution of environmental benefits.
So are you taking the priorities for reform?
I will take the first group.
Okay.
Priorities for reform.